It's a good question. Actually, it's a great question. I get asked this all the time with respect to international law. I get asked it because I'm a lawyer and a law professor, and I have a great deal to say about international law and its application to the Israeli-Palestinian conflict. And I'm often asked, well, if it has so much application, why isn't there change? Why is there so much status with respect to the conflict? Why hasn't all this body of international law moved or changed this conflict in all these years that we've been passing resolutions and writing textbooks and drafting reports? And I have to say that there's probably no conflict in the world where there is a greater gap between international promise and international performance. There is no conflict in the world which has attracted so many UN resolutions, so much diplomatic oxygen, so many scholarly pieces of books and articles on this particular topic, and has so, if you like, has so enriched international law itself. The laws of occupation, the rules with respect to illegal settlements, the laws of terrorism, when does an occupation begin and end? All of these finer points in both international humanitarian law and international human rights law have actually been greatly enriched by this conflict and all that's been written about it. And the great paradox, of course, is that very little of that great body of international law has ever made its way down to the people for whom it's meant to protect. And there's a book I read recently that comes from around 2004 by a legal scholar named Jean Hellon called Middle East, International Law in the Middle East, Closer to Power Than to Justice. And I thought, if ever there was a single sentence, a single phrase that could encapsulate exactly why law has been so hopeless with respect to this, it is that. And I guess the other thing I'll say, because I want to make sure everybody has a chance to answer questions, is, and I've said this over and over, particularly in the course of the last 2 days, is that A word. Repeatedly, we bring the term accountability. I sat most of the day yesterday listening to the Item 7 debate in the Human Rights Council. I listened for the entire debate discussion with respect to the introduction of the Commission of Inquiry's report on the shootings of the Gaza frontier over 2018. They've called for accountability. In 2014, the commission by Judge Mary Davis called for accountability with respect to Operation Protective Edge. Judge Richard Goldstone, at the end of his report with respect to the war in Gaza in 2008-2009, called for accountability. The International Court of Justice in 2004 has called for accountability. Well, if you're seeing a pattern here, you'll know that I've told some of you already, my next report in October 2019 is going to be on accountability. This is the elephant in the room. This is the unavoidable topic. We cannot keep on talking about the finer points of international law, which I, as a professor, of course, I love to do, but without realizing that there has to be some kind of answer in international law. And you know what? My final remarks are these on this particular question. There is an extraordinarily rich history in the United Nations and in other international organizations of taking countermeasures, I'll use that term for the moment, against states or situations where there are egregious human rights violations or other sorts of violations of international law. It is not as if the international law is soft law and there can't be steps taken towards it. Just the opposite. There is an enormous amount of precedent with respect to this. That's something that I hope to explore in my upcoming report, and I want to be able to put it to the world, is that it's not as if we don't have choices. If you're not taking these choices, that's your political decision, and you should be held accountable to your political decision.
As I, as retired Secretary of the UN Human Rights Committee, now, to what extent do you think that the major obstacle is not just the United States and what the United States wants to do with its agenda, but to what extent is it that the media has so badly reported on the situation that the great masses of people are more inclined to believe the narrative of Israel, or the narrative of the United States, that is a matter of Article 51 of the UN Charter. It's a matter of self-defense, and therefore we have to tolerate it. The media sold us the legality of the war against Iraq in the year 2002, which may be the greatest violation of the Nuremberg principles since the Second World War. We have been swimming in an ocean of lies. The media continues with its dissemination not only of fake news, but of fake law. So people think that some of the things said by Judge Bergenthal, that is the correct interpretation of the law. And if you repeat it often enough, non-lawyers will believe it. You won't believe it, I won't believe it. But they are selling through the media, or they're indoctrinating the world to accept the fait accompli, to accept the ex factis oritur ius that Israel has imposed on the Palestinian people.
I'm happy to answer that at some point, but I want to make sure both of you have a chance to answer as well. So why don't you go ahead and I'll add my points.
No, I just want to comment on a very short sentence, Professor Desais. When I was working in the West Bank for 9 years, I was exposed through humanitarian diplomatic tours to a lot of people that are from the diplomatic corps and so on. And sometimes it's not just the media that misrepresents the law. The law is simply not known by those who should at least understand the essence of it. But one of the questions that came to me most often during those 9 years, when I was representing the UN or the ICRC, was, and what do you do for the people on the Israeli side of the wall? And of course, anybody that studied law will say, well, this is a totally stupid question. I mean, what, to help the occupier? I mean, but that was one of the most frequent questions by people you think should know better than that.
Yeah.
No, sorry, that was...
I also want to say, I'll say just very briefly with respect to this, that I recognize the problems with respect to media coverage, and it's particularly so in my own home country of Canada. This conflict gets virtually no coverage whatsoever, and when it does, it tends to be deeply filtered, if I can use that. But I also want to say that we're not empty vessels to be poured into by poor media coverage with respect to any conflict, let alone the Israeli-Palestinian conflict. We all have agency. And recent opinion polls in Canada have said, notwithstanding the utter silence in the media in my country, there actually is almost a split opinion among popular opinion with respect to how they understand the Israeli-Palestinian conflict and which way they wind up leaning. Which gives me great hope that despite media, that people find A, sources elsewhere to want to try to make up their opinion, and B, that for most of them, the conflict was a lot simpler than what some of us have made it out to be, and that there is a occupier and there is an occupied people. There is a David and there is a Goliath with respect to this, and they understand it in those terms. So while I, like you, am cynical perhaps or skeptical with respect to most media coverage, I understand it's not the world. We're not the empty reflectors of what the media winds up telling us. And the other thing I just want to say with respect to this, it's not black and white with respect to Israel either, or with respect to American Jews, or diaspora Jews, what they think on this. some of the best legal scholars I have read with respect to the Israeli-Palestinian conflict, who've taught me a lot with respect to what law applies and how it does apply, have been scholars, obviously one of my predecessors, Richard Falk, but who I turn to first, actually, is a body of fine, liberal, and progressive Israeli legal scholars. I think of Eyal Gross, or Orna Ben Naftali, or Ayam Ben Venisti, or Michael Safard, or Hadi Vatay. All of them have written wonderful, insightful, deep-thinking pieces with respect to Israel, the occupation, and international law that I've learned a lot from and have educated myself. So, in any situation, there's always going to be this a yin and yang as to what's struggling to wind up dominating the other. So, if behind the question you originally asked is, do we have any hope, or is international law, a fine ideal but really of no practical assistance? I say it is. International law does not belong to lawyers alone. International law ultimately is the reflection of our moral values, just the same as domestic law is the reflection of our moral values in any particular society, in any particular time. And international law espouses, as most with respect to humanitarian law and human rights law, the very highest ideals that have motivated us for the last almost 75 years in the aftermath of the Second World War. And that's why I want to have hope. And if I have hope for one other thing, and then I'll be quiet, it's that there are both Palestinian and Israeli human rights defenders, civil society groups who do excellent work on the occupation. Israelis and Palestinians alike who speak the very same language on human rights and international law. And I always try to end any of my gloomy lectures about how bad things are with an optimistic note that these Israeli and Palestinian human rights defenders speak the same language, working towards the same goal, and they're the bridge for a future society.
It's very good to hear an optimistic note. We don't often have it in these sort of debates. Are there any other questions? Any comments that anyone would like to make?
Over here.
I would like just to answer to Mr. Isaiah. Thank you for your question, and actually thank you to the Palestinian permanent mission of organizing this event. We're all very pleased to be here to seeing the film screened, and I'm personally very pleased to being here together to have an opportunity to not only address Mr. Desai's question, but also to add something on what Michael just mentioned. With regard to the misinformation and kind of reluctance of the press to rectify some of the misunderstandings, I think it is a little bit like in parallel in the national practice cases. You very often see what happened in the ICJ advisory opinion case was an attempt to disinform and to shift all focus on Article 51, which is the right of Israel to self-defense. And actually in the national law cases you see the same. Lawyers always put in front or put an emphasis on those arguments, of course, which will serve their case. What unfortunately did not happen was that the press did not really rectify that, whereas the court did rectify. Actually, in some national cases, you have the court so much overwhelmed by misinformation that they even take the incorrect or not really right decisions. In this case, I think legally the ICJ advisory opinion is perfect in its findings, but I think actually it was not only the media which were reluctant in rectifying public opinion on Article 51, but there is a lack of political will, which brings me now to what Michael said, to the question of how can we reinforce international law, and not only reinforce the material law, but the procedural law and the enforcement mechanisms. if you look into Common Article 1 of the Geneva Conventions, which is largely mentioned in the advisory opinion, which says that states shall respect and ensure respect of the Geneva Conventions. It is, of course, you can say it's kind of a general appeal to states not only to not violate the Geneva Conventions, but also to induce other states, which might be violating international law, to get back on the legal ground and not to violate. I think a lot of work should be done in the near future on that Common Article 1 obligation, and also seeing that maybe states could use that Common Article 1 to further respect of the advisory opinion, and to what Michael said, to not only look at what states could do, but what other entities of society could do. I mean, I only saw a video of a debate which was following a screening at the Graduate Institute, where Georges Abissat, whom some of you in this room know very well, mentioned the possibility of civil society movements to further respect of international law, which I personally very much like. I mean, of course, we have the whole set of standard mechanisms of implementation and enforcement, like from diplomatic relations and withdrawals and sanctions and whatever, but sometimes you can feel quite powerless when there is no political will. And I think this is where we can really work on it. This is where, personally, Mr. Miron, Judge Miron, gave me full enthusiasm and a real wish to work more on, is to kind of encourage civilian society to work more. Thank you.
I have one more thing to say. Okay. I don't know why I completely missed it. This was a wonderful film. I really enjoyed it. I've got to say, I saw a film on Friday, which I enjoyed as well at the film festival for human rights here. But what I really liked about this film, what I found a bit distant in the film I saw on Friday, was that it read like a prosecutor's case. It was one fact after another for one particular side. And I didn't get the nuance, I didn't get the subtlety, and I didn't get exposure to the other side. What I really liked about this was that you went and interviewed, Judge Blumenthal, and you gave, you interviewed Israelis as well who may not have been sympathetic to what the film was doing. I just felt I had a much richer understanding of what was going on around the passage of the resolution in the General Assembly, and then going to the International Court of Justice. So this struck me as being a much more well-rounded film that I could have actually a lot of trust and faith in. And the other thing I just want to say about international law to all of you is, among lawyers, when we deal with law, we recognize that at some point, some laws are very vague, and we're really in the very beginning of trying to understand what the meaning is and what the purpose is. And then other laws, there's a clear path coming forward, but there still is a strong minority view with respect to it. And at some point, the law is absolutely clear, and there's really no doubt as to what the law is. And we are at that third stage with respect to international law on Israel and Palestine. And I was going to call this a wall-to-wall consensus, no pun intended, obviously. But when we talk about, is there an occupation? It is absolutely clear in international law that there is. Are the settlements illegal? Not only that, but they are I presume, war crime under the 1998 Rome Statute. Is annexation, particularly annexation of the Golan Heights and East Jerusalem, unlawful under international law? It is. There is no debate with respect to that. Are there a wide-ranging violation of human rights, such as collective punishment, both under humanitarian law and international human rights law, occurring? The law is so overwhelming with respect to that when you see alternative opposing arguments coming up, they really are akin to the tobacco lobby telling you that there's nothing wrong with cigarettes, or with climate denial climate deniers with respect to, or flat earth. Really, the law on those areas is that thin. We are at that stage of broad consensus as to what the law is, and those who are fighting against it know that they have no legal argument to be able to make with respect to this.
A question, that was something that I wanted to say something after.
Finally, a question. What role, if any, for the International Criminal Court, for universal jurisdiction, and for people's tribunals?
Look, I'll start with this, but neither of you, you should get over your shyness with respect to this. It's fun to talk into this. There are two potential forums now that hold the promise of accountability. One is the International Criminal Court that Alfred has just mentioned, and someone wrote a book I read recently about the creation of the International Criminal Court, and it was The Sun Rises Slowly is the name of the book. And I thought that was an apt title for the acquisition of universal justice and for the work of the International Criminal Court. As my understanding was that the two complaints are made by the state of Palestine in early 2015, so they've been at the court for 4 years now. One with respect to the 2014 war in Gaza, and the second with respect to settlements. And that there have been subsequent complaints added to that on more recent events. And there probably will be complaints with respect to the findings of the Commission of Inquiry. We can only hope that we will soon hear from the Chief Prosecutor as to her decision on the first of the 3 levels which cases go through, as to whether or not it clears that first level. I can understand the time they may want to take with respect to the issue on Gaza to ensure that they have a wide enough range of solid evidence and facts to be able to justify going forward. But to me, the issue with respect to the settlements is really a legal no-brainer. So it's so self-evident that they would be contrary to international criminal law. The second thing I want to say is the International Court of Justice. And what I would say to Palestinian civil society, and what I would also say to official Palestine as well, is that I think there is time and there is room for a new advisory opinion to be put to the International Criminal Court. In my October 2017 report to the General Assembly, I laid out what I thought were the factors saying that Israel is now the illegal occupant of the Palestinian territory. That the 4 primary foundational values and principles going to the laws of occupation. 1, that the occupation is to be as short and reasonable time as possible. Number 2, there shall be no annexation. Number 3, the occupier is to rule in good faith. And number 4, the occupier is to act as a trustee for the best interests of the people, protected people. Israel is in violation of all 4 of those foundational principles. No, and you think of all the classic occupations that have occurred in modern times. How long was the United States and Japan after the Second World War? Roughly 10 years. How long were the Western Allies in Western Germany after the end of the Second World War? Roughly 10 years. How long was the American-led coalition in Iraq after the 2003? Whatever we may say about the illegality of the war, they were there for roughly 9 to 10 years. That is more or less the maximum time period for an occupation to take place that meets with the criteria of good faith. This occupation is five decades and counting, and there can be no justification. In fact, I argue in my report that the longer the occupation, the higher the onus and obligation it is for the occupying power to justify why they still are there. And there can be no justification that meets with the laws of occupation with respect to that. If we were to then trigger a new advisory opinion to the International Court of Justice, be successful with it, it would be, I think it would take us a step beyond the 2004 opinion. The 2004 opinion established the illegality of the wall in its location. It established the illegality of the settlements. It established some other legal points which are important to us. But in some ways, we've drained all the orange juice we can from that particular orange. We need to go get a new orange and start using new juice with respect to this. And if the occupation was to be declared to be illegal. As you saw the German judge say, I didn't see that in the 2004 opinion, but he said the occupation was illegal in the film. Then I think that raises the obligation on the international community to bring this occupation to a successful and just end.
So, are there any other? Yes, please.
Hi, I'm Chris Grossi, I'm with Geneva International Court of Justice. As an international lawyer, I'm compelled by the idea of having another advisory opinion and bringing into the court the larger questions around the entire situation rather than just one small piece of it. But I also think the message given in part of the movie, that the more, I think it's also a compelling argument that the more we take to the court and the more we get decisions that are not ultimately implemented, that this can result in, if not, I mean, certainly a lot of people believing that international law has no value, but also ultimately possibly a degradation of the value of it, really. I mean, can you talk a little bit about that and whether or not a second, I mean, is a second advisory opinion going to be any more effective than the first one? And is there still value in it?
I've spoken more than enough, so please.
I will just jump on the first thought I had when you said, like, is it a good thing to seize the court when you know in advance that the opinion or the judgment might not be implemented? You make me think when how I react when a client is coming to ask me, does it make sense to sue a particular individual for a particular amount of money when we know in advance that there is no money to be seized at the end? And I would still say yes. It makes sense, because we need first to have a judgment, to have it written down, to have it recognized what is the legal situation. And at the second step then, we ask the question of the implementation and the enforcement possibilities. I think it's a kind of a two-step decision you have to make, and very often to win the public opinion and the public mind, it's important to have the first level done first. Thank you. Actually, I can imagine that Michael has many more thoughts on that, so I really invite him to further develop.
I'll be very, very brief with respect to this. One of my great legal heroes is Avi Sachs, the South African judge who sat for 15 years on the South African Constitutional Court. And he said in one of his great books, he said something effective, it is entirely acceptable to be skeptical about the law's promise, but it's never right or justified to be cynical about the law's achievements, and that the law can wind up giving us many, many things with respect to this. But it goes back to the question we raised before, the A word, accountability. And if we begin to think creatively of how you use victories in law, because the law is on side of ending the occupation, the law is on side of supporting self-determination, the law is on side of ending the settlements. What we have to do now is make sure that legal moral values that align with diplomatic and political work with respect to that. And I would never be one to think that law alone is going to settle or achieve final justice in the Middle East. Law is but one of the several tools that are available. But we should never scorn the availability of those legal tools as a means of pushing forward. We just have to recognize that many other ways that this particular conflict and struggle has to be pushed forward in other forums as well. At the end of the day, you think there's one superpower in the world, the other superpower has to be public opinion. And I think, the world over, You know, if the Palestinians have only two things on their side, it's international public opinion and it's international law. And the trick is try to find and create a way of marrying those things together to push their struggle forward.
Although I'm the only non-lawyer on the panel here, when Michael Lynk talks about the A word, I think that's very important. It's the accountability. When I think back of my work experience as a humanitarian, there's another word. It's the R word. It's the responsibility of all of us, the international community, to actually defend the kinds of laws that we create in the, you know, in those organizations. Not to take responsibility at any state, having a 2004 ICJ opinion and shying away, in your country, very much so, from taking a side. I think that's, you know, that's something to think, to thought of as well.
There is nothing I want to say some words because I think no questions more. So first of all, I would like to say microphone. Yeah. Okay. Good afternoon, everybody. I would like to thank your presence, your interest to listen for such an interesting interventions from the panelists, like in all, and watching the screening is very important also, especially for the diplomats, those who are working with the legal institutions and they are studying in the universities. Very important and rich case. I want to say some comments and remarks. I don't believe that this idea that the Israelis are trying to convince and others are repeating the same, that Israel have the right to defend itself. I don't understand that. As an occupying power, they have no right, even legally. So we should stop with that. If they want to defend their security, they have to end their occupation. Then we will have our security and they will have theirs. But to guarantee their security far away from ours, there is no logic on that. Saying that, because the majority from our friends around the world, and especially the influential countries, they are trying to convince us that this is the way. We did our utmost to behave and to use the legal path to defend our cause. As under Yusuf, they are blocking us, even to benefit from this advisory opinion. As the judge from the States, he said, I'm a Jew. I think Judaism, Islam, and Christianity not collapse with international law, something totally different. This is another remark that we should take it in consideration if we are going to continue in this way. And after now, what we are living all is a serious attempt and a threat to undermine the international legal system. During the film at the beginning, we started with this international law since the 16th century, I guess. It took us a lot of time to reach to what we have now. I realize that we are in need maybe for some reforms to the international legal system. It's a transitional period now for all of us. But to keep what we have now, not to use the unilateral vision for this international policies now they are representing with the new administration, and the Israeli lobbies around the world are working for that, which is very dangerous. They are endangering the security of the international world. Yesterday, it was a demarche by the Israeli mission here in front of the UN, and you can see that, can imagine, the ambassador of the United States from Germany are coming to another country, to Geneva, to march against the Human Rights Council and the Item 7, and he is considering the Human Rights Council is anti-Semitic body. Where we are what he's doing. And some are listening to him. They should leave the place. What's that? If we continue in this way, what's happening in New Zealand and what's happening yesterday in Netherlands and today in Norway, it will go ahead because there is two law, international legal system or the international law or the jungle law. Our neighbors, they want the jungle law to be there and they will benefit from all of it. So we should be careful for all of us, for our future, our children, even that in Europe or everywhere. If we leave the things flowing on this direction, we are endangering ourselves and endangering this entire world by giving those who have the power. And maybe in our case, we realize, and this is a recognition in front of you, we realize that Israel is the most powerful in the region, financially, not only military and military, but in history it's changeable. The thing that is not changeable, the will of our people, the justice of our cause, and the support, the legal and the moral, and the logic of our cause. So they didn't defeat us since the start of the occupation, 53 years, and we will continue. Now is the time for all to wake up and to see what's going around in Europe. There is some from Europe here. It's very dangerous. The wave of anti-Semitism is growing speedily. Anti-Islam is the same. But for me, behind all of that, I'm not exaggerating the things, but behind all of that is the Zionism. Go ahead, 100 years ago, and read what's happened at that time. You will see the same in different format and different restructuring. So it's very dangerous. We need wise people, and we should respect our international legal obligations. And I hope that it will be the way and the path for all of us to guarantee the security in this global world, and to turn to face the global challenges, and to keep you working. In this way, you will not find the work as a lawyer. Yeah. Because the real estate law is not going to apply anymore. So once again, I would like to thank the audience and to thank you, the panelists, for organizing this event with us. And I hope one day that we will celebrate with you as the Israeli soldier. We will take those and put it on the right place. We are not against that. Thank you.